So
Okay.
I saw your
Sorry.
words there, and your words are not appropriate in court, and I know you mouthed them,
sorry.
but
I'm sorry.
that's me admonishing you to say, I get it, and I understand that's a lot. So it sounds, but what, you know what you could do, and I'm not giving you legal advice, you can call Washburn County and see if you can get on a payment plan. At that time, they may be able to release your ability to get your license back, and it may be cheaper, but you're going to have to make that payment plan. Otherwise, they're not going to work with you. Okay? So why aren't you working?
I actually just, I don't know what happened. I was sick and I got terminated from A&W just the other day.
Okay. So you're going to look for another job, right?
Yeah.
Okay. So that's good. So you're not just sitting down doing nothing and eating bonbons and watching soap operas if they exist. Okay. So that's good. So here's the deal. I'm going to set it for a date later in time. You're going to call Washburn County and see what can happen there. You're going to talk to Amy before you leave and see about the ignition interlock device and the half price thing. We will go on the record. It's possession of THC.
I know. I just want to make sure he has a complaint.
We'll go on the record in the matter 26 CM 25, State of Wisconsin versus Jacob Ford. The state appears through District Attorney Kevin Schmidt in person. Mr. Ford appears in person with counsel Joel Feliski making a special appearance on his behalf here today. We're set today for an initial appearance. Is this a case that we can get an offer right now or proceed normal course?
This is one where we sent a letter offering participation in our THC diversion program, but never got a response. If you completed it, we dismissed the case. Is there any interest in that?
Excellent. I'm glad to hear that, Jacob. All right. So what we're going to do here today is I'm going to schedule you for another date, just like the guy who was right before you, okay? And so I'm going to schedule you for May 27th at 1. When you're done here, you're going to do just what that gentleman did. And you're going to go to the district attorney's office and you're going to talk to Shannon. All right. She's going to give you all the things. It's a very quick program to do, but make sure you do it right away. And then you won't need to come back to court. Okay. All right. So you can come get your notice and you're free to leave. Jacob, you still on Skylight Drive? Can I get an updated address?
358
East Cedar and Webster. And I am going to need a telephone number too. Do you have one?
715.
All right. I'll give it to you. Okay. Well, let's just do it. Okay. Address? Because you can it or not. Because that's fine. I gotta open it up. It automatically closes. All right. 7358 East Cedar in Webster. Okay. Telephone 715-416-4099. Okay. All right. All of you are waiting for Mr. Feliski? Is that a yes? No? Who are you, sir?
Mr. Pearson, Timothy Pearson.
Timothy Pearson. Come on up. I appreciate your attire.
I'm on my way to work.
What do you do?
Security supervisor at Danbury Casino.
Nice. Nice suit.
Thank you.
We will go on the record in the matter 26 CM 45, State of Wisconsin versus Timothy Pearson. The state appears through District Attorney Kevin Schmidt in person. Mr. Pearson appears in person without counsel. We're set for an initial appearance, but is there an offer that can be presented or are we going down normal course?
We sent a letter to the address but got no response for this one. We have a THC diversion program where if he's interested, it would result in dismissal of the charges. Is that something you'd be interested in?
I am interested in that.
Same script that we have had for the last two people. And you want to do that? So what I'm going to do is I'm going to schedule you for that May 27 at 1 date.
Okay.
You're going to go talk to Shannon in the DA's office, get all the stuff, do the program as quickly as you can. And once you complete that, you do not need to come back to court on that 27th.
Okay. Perfect.
You come get your notice and you're free to leave.
Thank you, Your Honor.
Well, thank you. Who are you? And you're waiting for Mr. Flisky? Or no?
Toner's running out, so I just keep making sure that he can read it.
Why don't you come on up? Deandra Carrillo? Deandra Carrillo? We will go on the record in the matter 26 CM 40, State of Wisconsin versus Deandra Carrillo. The state appears through District Attorney Kevin Schmidt in person. Ms. Carrillo appears in person without counsel. We're set here today in this matter for an initial appearance. Ms. Carrillo, did you receive a copy of that criminal complaint?
I don't believe so.
Mr. Schmidt will get you a copy. It has 4 charges, and I'm going to go over them with you, and then we'll see where we're going to go from there, okay?
Okay.
All right, so you see those charges.
Yes, Your Honor.
Count 1 is operating with a motor vehicle while revoked. It's alleging on or around February 13, 2026 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway during such revocation period or thereafter. And that revocation resulted from an offense that may be counted under Wisconsin law. A maximum possible penalty could be a fine of not more than $2,500 or no more than 1 year in the county jail or both. Count 2 is failure to install ignition interlock device. It alleges the same date, the same time, the same place. You failed to have an ignition interlock device installed as ordered by the court. Maximum possible penalty could be a fine of not less than $150, but no more than $600, or imprisonment not more than 6 months, or both. Count 3, possession of THC. It's alleging the same date, the same time, the same place. You knowingly possessed a controlled substance, THC. Upon conviction, you could be fined not more than $1,000 or imprisoned not more than 6 months, or both. Count 4, possession of drug paraphernalia. It's alleging the same date, the same time, the same place. You knowingly possessed with a primary intent to use a metal grinder and a glass smoking pipe to store and smoke a controlled substance. Upon conviction, you could be fined not more than $500 or imprisoned not more than 30 days, or both. Do you understand all of those counts?
Yes, Your Honor.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Still on Eagle Feather Drive.
Yes, Your Honor.
May I get a telephone number, please?
715-471-0958.
Maybe send you text message notifications.
Yes, Your Honor.
Mr. Schmidt, is there an offer that can be presented?
The offer in the case would be plead to OAR and IID for the DNA surcharge on each totaling $400.
Okay, so plead to the operating while revoked and the failing to install ignition interlock device for costs,
Yes,
and dismiss the other 2.
correct.
All
And
right.
the basis of this is it's not possible for her to get a license till at least December.
Okay, so go ahead.
Sorry, I just have a question. I didn't know I had my license there for a minute. I paid the AODA thing in Aurora and all that, and I had my license, and I didn't know I didn't have it until I got pulled over. But I am okay with the
You
deal.
want to accept that offer?
think so, unless there's a way I don't even know how to get this thing. I'm sorry, I'm not really,
The ignition interlock device?
yeah, I don't know who to talk
You
to.
would need to, and you still have to do it, even if you plead to these charges. go talk to Amy at the clerk's office. She is our guru and has all of the information of all of those types of things. And she can tell you, and you can also get a half price application where you fill that out and I sign it and you can get it for half price because you still need to do that. I don't know what else you need to do. It sounds like you went to Aurora and you did that. Usually there's steps after that, and it sounds like those weren't taken. So you may need to redo the Aurora thing. I'm not sure on that,
Okay.
but what you would need to do is you can either talk to the DMV, you can ask Amy, she might be able to find that out there,
Okay.
or you call Aurora and you ask them if you completed all of their steps at least, okay? And so you're here without an attorney. Do you wish to have an attorney or do you want to represent yourself?
I'm not sure. I don't know if I should. Do you think I should? I don't know.
I can't give you that
Okay,
advice,
sorry.
but what I can do is give you some time to think about it, okay?
Okay.
So either you can come back and say, you know what, Judge, I accept that offer. I want to do it right now. Let's get her done. And I can go ahead and take your plea. If you say, if you want an attorney, I'm going to expect that you have at least applied for the public defender or you have an attorney before you come to the next hearing. Okay?
Okay. Your Honor, sorry.
Do you have something else?
So for those two, it would just be 400 for both of those. I'm sorry. I don't really have a job right now. I'm just trying to go for the cheapest route. So.
And it's not going to be cheap to get your driver's license. It's
Oh, no, I'm not talking about,
I
I'm
know,
sorry. It's just the
but
fines.
even the ignition interlock device. And I'm not sure if you said DNA surcharge only.
Yes, and part of that is because of the reason her license is suspended is she hasn't paid off the OWI fine originally from Washburn, which is like
Thank you.
$1,300.
That's why. So
Okay.
I saw your
Sorry.
words there, and your words are
Sorry.
not appropriate in court, and I know you mouthed
Yep,
them,
sorry.
but
I'm sorry. Your
that's
Honor.
me admonishing you to say, I get it, and I understand that's a lot. So but what, you know what you could do, and I'm not giving you legal advice, you can call Washburn County and see if you can get on a payment plan. At that time, they may be able to release your ability to get your license back, and it may be cheaper, but you're going to have to make that payment plan. Otherwise, they're not going to work with you. Okay?
Okay.
So why aren't you working?
I actually just, I don't know if I don't know what happened. I was sick and I got terminated from A&W just the other day.
Okay, so you're going to look for another job,
Yeah.
right?
Yeah.
Okay, so that's good. So you're not just sitting down doing nothing
No.
and eating bonbons and watching soap operas if they
No.
exist. Okay, so that's good. So here's the deal. I'm going to set it for a date later in time. You're going to call Washburn County and see what can happen there. You're going to talk to Amy before you leave and see about the ignition interlock device and the half price thing. All right. You're going to, I'm just going to say, and call the DMV and see if there's anything else you need to do. All right. You're going to let me know. And then if you wish to accept the offer at the next time, I'll go ahead and take your plea. And he is recommending to the court only the DNA surcharge, which is mandated. So that's 200 per. So that's 400 total. And payment plan would be fine. With the caveat that you probably heard or you know that I follow that very carefully, and I will issue a warrant if you miss a payment. Okay? And you could sit up to 6 months in jail. So this is a Mr. Schmidt. How long would you think you need to think about it and get those things done? A couple weeks?
Yes, Your Honor.
How about April 21st at 1:15? Okay?
That works, Your Honor.
April 21st at 1:15. Make sure you get all of those answers. There's a pen there if you need to write down and remember all the things that you need to do. You can come up here when you're done and you'll get that date and time in a printed form. So you'll have that. Just, I want to make sure that you do all of those things so you can come back and update me, okay?
Payment. I'm sorry, do I get up or? Okay, sorry. Do you just want to sit back down?
You're free to go.
Okay.
Just go talk to Amy. Talk to Amy. Go right out there and talk to Amy. We're supposed to. I don't know where he went. He confirmed this morning he will be here at 1. And I don't know. Do I issue a warrant for the attorney and the defendant?
But he can't fish.
He's out fishing for them walleyes.
He's fishing for the walleyes. We will go on the record in the matter 21 CM 112, State of Wisconsin versus Angie Jones. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Jones in person without counsel. We're set here today in this matter for an initial appearance. This has been charged as resisting or obstructing an officer and an OWI second allegation. Ms. Jones, off the record, you stated you do not want an attorney. Is that correct?
I don't think that I need one. I think
You have every right, constitutional right, to represent yourself. So you can do that. I do have to let you know that with the resisting or obstructing, the state would have to prove on or around January 28, 2021 in Burnett County, Wisconsin, that you knowingly resisted an officer while an officer is doing an act in an official capacity and with lawful authority by failing to comply with law enforcement commands. If you were convicted of that, you could be fined up to $10,000 or imprisoned up to 9 months or both. Okay, so do you understand that part?
yes, I do.
With an OWI second, that is, it's different than in Minnesota. All right. Called DUIs over there. They're OWIs over here. The way Minnesota handles them is completely different than Wisconsin handles them. With the OWI second, that means that the state would have to prove the same date, time, and place that you were under the influence of an intoxicant, and it would be your second countable offense. That's a misdemeanor. Upon conviction, you shall be fined not less than $350, but no more than $1,100, and imprisoned not more than 5 days, but no more than 6 months. So that means this is a jail sentence of at least 5 days. All right, so do you understand that?
Yes, I do.
And so knowing that, do you wish to seek an attorney, or do you can still represent yourself?
I'd like to still represent myself.
All right. And so with these two counts, you wish to plead not guilty, correct, at this time?
At this time, yes.
Okay, not guilty pleas will be entered on your behalf at this time. You are entitled to a jury trial. You would be entitled to a speedy trial once you request, or if you request one. I have to ask you a few questions, and I'm not trying to be rude or picky or anything like this, but how old are you?
48.
Can you read, write, and do you understand the English language?
Yes, ma'am, I do.
And any mental illnesses or disorders?
No,
Anything interfering with your ability to comprehend or understand things?
no, Your Honor.
Do you understand that a lawyer goes to law school to be able to learn the law and learn how to negotiate and look for defenses, or if you don't have any defenses, and make arguments and those types of things? Do you understand that?
Yes, I do.
So do you understand that there are certain disadvantages to not having a lawyer?
I do.
Okay. I just need to ask those things to make sure. At this time, is there an offer that can be presented, Mr. Schmidt?
Yeah, one sec.
Or do you need some time to think about it?
The offer would be if she entered a plea to the OWI2, we'd DRI the resisting, we'd find the refusal to be reasonable, and we'd use the lowest guideline.
All right, so in English, you want to know what that means, or do you understand?
If you wouldn't mind, I would
Nope.
appreciate that very much.
There's a lot of legal jargon, and, that's why lawyers are lawyers. Sometimes legal language is even complicated for lawyers. What the offer is to plead to that OWI second charge, okay? And to dismiss and read in, so to dismiss that other charge of the resisting the officer, which is that other misdemeanor. In this case, there's an allegation that you refused to provide any PBT, to do field sobriety, those types of things in this. And so under Wisconsin law, a refusal could be serious. They can try you on the refusal, and that would need to go first, and then try you on the OWI second. But they are saying that right now, if you accept the offer of the OWI second, dismiss that other count, they would deem that refusal as that it was reasonable, that they're just kind of going to overlook that, and it won't be additional things and sanctions and punishments, okay? So that's the offer. Do you understand that?
I do.
Okay. And so I'm not going to, unless you know right now, I'm not going to ask you if you wish to accept the offer right now.
Thank you.
I can give you time to think about it. So would you like some time to think about it?
Yes, please.
Okay, because again, the minimum here would be 5 days of jail. But with Wisconsin, there's something called good time, which means it could be down to 4 days. However, there are certain things that can be argued to the court. Even in Minnesota, you can do this, but it's at your cost to have an electronic monitor and have house arrest. All right, but you have to prepay that. It's $25 a day. It would be 4 times 25, $100. But you can't do anything but work or doctor's appointments. And that would be it, because it's house arrest and it's GPS monitored and it's blood and drug monitored, okay? So that's an option too. So, but you would have to argue that to the court and tell me why, all right? So how long do you want to think about whether or not you want to accept this offer? You want a couple weeks? Or do you want a month?
Not a month, no. A couple weeks would be sufficient.
All right. If you accept the offer, I will need you to be here in person. And if you accept the offer and you want to argue the electronic monitor, I'm going to need you to let the court know ahead of time that I'm going to accept the offer and I'm going to argue the electronic monitor, because it's not something that can be bing bang and you can be hooked up right away. But the court can then say, I can give you up to 45 days to report to get hooked up. But if you don't report within that time, that could be a felony escape. Okay, so I'm telling you all the things, and I know it's all overwhelming, but I have to tell you all the things. Okay?
I appreciate that.
All right. So I'm going to schedule you for April 21st at 1 o'clock. All right? April 21st at 1. Do you have a job?
Yes, I do.
Where do you work?
I currently work 2 places. One, I work for a contractor who, it's Ryan James Construction. It's a very small business, but I've been employed with him for the past 3 years. And
Is it flexible so you can come and this isn't going to quite interfere?
yes.
Okay. And your other job, it's okay too?
Yeah. Yes. The other job is at a bar restaurant, but
And I'll let you know if you do accept the agreement. I'm going to tell you, because I like people to know all of the things, that that 5 days of jail, it would be 12 months revocation of your Wisconsin driver's license. I don't know how that impacts Minnesota. You have to talk to Minnesota. And it would be $975.
Okay.
That would be the fine.
Okay.
So I just want you to know that stuff. Okay.
Yes.
All right. Because you were saying the lowest guidelines, right, Mr. Schmidt?
Yes.
I did the IDIP, so that's good, that's fine? With the dollar? amount?
Yes.
Okay, all right, so come get your notice and you're free to go, okay? Just make sure you're here on that date and time.
Can you give it to me one more time?
You're gonna come up here and she'll give
She'll
you a
give it to me,
printed notice, all right?
Thank you.
She's technically an electronic.
She's an electronic filer? You electronic filer?
I just did that because I was on.
Oh. Is there a way to get her out of being an electronic filer? Nope, you're stuck. So that's fine. She's gonna print it out and you're all good. You're good.
This will still come through.
Yes. Yep, it'll come through in your email and all those things too, but now you have it in written form. Okay? All right. And I verified your address and telephone number, right? No, let me just see if, because I want to make sure. Is it on Jackson Street Northeast?
Yes.
And telephone ends in 9898?
Yes.
Maybe send you text messages?
Yes.
Excellent. Thank you. We're all good. Who do I have in custody? I have 2 people in custody and I can't see you or hear you. Mr. Avery?
Yep.
All right, and who do I have in the other jail? Maybe they're not there yet. Nobody yet. Okay, thank you. Okay, maybe not. I don't know. We'll see. Who are you?
I'm Darcy Dimon.
All right, thank you. Oh, Miss Dimon, your case
Yes.
has been moved to tomorrow at 2:15, okay?
Okay, thank you.
All right, so you can just tell them it's been moved to tomorrow at 2:15.
All right, do you want me to just X out of here?
Yep, you can just, yep, or I can remove you, that's just fine too.
Okay, thank you.
Is Mr. Flisky outside?
Yes.
Can you hear me? You
Right.
can hear me better? Oh, excellent, excellent. All right. We will go on the record in the matter 25 CM 115, State of Wisconsin versus Gerard McKee Sr. The state appears through District Attorney Kevin Schmidt in person. Mr. McKee appears in person without counsel. This is a simple simple disorderly conduct. Before we proceed, is there an offer that can be presented? He has posted, maybe not. I don't think he's posted anything.
I posted a 250.
250, you did? All right. So he has $250 posted. Is there an offer that can be presented?
The offer would be an ordinance for costs.
All right. So Mr. McKee, Mr. Schmidt, the district attorney is offering you, he would amend that crime to a ticket. All right. For just a ticket. Do you wish to accept that offer? It would just be for costs and it won't be a crime.
For cost?
Yes. And
What is costs? What I,
$250. You already have it paid.
okay, that's fine. That would be, well, I hesitate to agree.
You're not admitting any guilt.
Okay, because I don't really feel guilty.
Well, it would be a no contest where you're not saying, I'm not guilty. I'm not admitting I'm guilty. I'm not saying, anything about the case. I'm willing to accept the responsibility of a ticket.
Okay, I would be willing to accept the forfeiture of the $250 bond and time served.
Excellent. Good negotiating. So formal motion to amend
So made.
granted. All right, no contest plea is going to be entered on your behalf. $250. Time served, you're good to go.
I thank you.
Thank you.
Should I leave these here?
Miss
Oh,
Olivia will come and
Pick
get
them
them.
up?
Mr.
Thank you.
Felicia and Mr. Avery.
Yes, Your Honor.
Well, that wasn't too bad. $250.
We will go on the record in the matters 21 TR 176, 177, 24 TR 798, 25 CM 133, 26 CF 33, and 26 TR 238. State of Wisconsin versus Ashley Avery. The state appears through District Attorney Kevin Schmidt in person. Mr. Avery appears by video conferencing in custody in Burnett County Jail. And we have his counsel, Joel Feliski, in person. We're set today in this matter for an initial appearance, and we also have statuses on the other matters since he is currently held on a warrant for fail to pay past due fines and fees. Mr. Feliski, did you go over the criminal complaint with Mr. Avery?
I did, Your Honor. I believe Mr. Avery understands the charges here and the maximum penalties. We'll waive formal reading, we'll enter in a plea of not guilty as to the misdemeanor, and we would request a preliminary hearing within time limits.
All right, not guilty as to the misdemeanor. Preliminary hearing. April 17 at 1. That works?
That will work.
All right, I will wait to address the fail to pay warrant until we move down the case, okay, Mr. Avery? Because unless you think that you can pay your $500 bail at this time.
No, I can't.
Okay, so then I'll address them both maybe at a later date. Okay?
Understood.
All right, thank you. We're adjourned. Tyrone Hoffbeck. We will go on the record in the matter 26 CM 44, State of Wisconsin versus Matthew Centerselli. The state appears through District Attorney Kevin Schmidt in person. Mr. Centerselli appears in person without counsel. Off the record, he indicated at this time he's not looking to retain counsel. Before we begin, this is an allegation of possession of THC and a bail jumping misdemeanor. Is this one that an offer could be presented right now, Mr. Schmidt? Or normal course?
This is a person where we tried to send a letter to participate in our THC diversion program, which would result if he did a short program, we dismiss everything. Did you get that in the mail? Are you interested in that?
I did not, but I would do that.
All right,
Okay.
so what I'm going to do is I'm going to schedule this for about a month or 45 days down the road. That class, it's very simple. You do it online and you just have to make sure that they get proof that you've done that. So when we're done here and you get your notice of the next court date, then you're going to go to the district attorney's office and is it Laura?
If you want to head down to our office, you want to speak to someone named Shannon.
Shannon? Okay.
Talk to Shannon.
Okay.
And then Shannon will tell you all about the program, give you what you need to know, and then you'll do it. And then you won't need to come back if you've done everything, okay? All right, so let's get this scheduled for sometime down the road. I'm going to schedule you for May 27th at 1. May 27th at 1. Again, if you get everything done and they're like, you're good to go, you don't need to come back. Okay?
Okay.
So come get your notice, then go to the DA's office.
Thank you, Your Honor.
All right, Mr. Feliski, who would you like to have go first?
Your Honor, I have a special appearance for Jacob Ford.
We will go on the record in the matter 26 CM02, State of Wisconsin versus Jillian Scottson. The state appears through District Attorney Kevin Schmidt in person. Ms. Scottson appears by video conferencing with approval of the court. We're set for a status conference. I believe an offer was either presented or you still needed to talk to the victim in that case. I can't recall off the top of my head.
I sent an offer to her by email only on March 31st.
Okay. And what was that offer? Victims' rights compliance.
Yes. It'd be a deferred judgment of conviction on disorderly conduct with various conditions.
All right. And do you understand what that deferred judgment of conviction document is, Ms. Scottston?
Yes, I do.
And you just received it on the 31st, but that should be some time for you to try and consider that. Is that something that you are considering, or can you give me an update?
I did respond to his offer on the same day via email, which he should have gotten that response also, which declined the offer.
All right. It declined the offer. And so at this time, are you going to be continuing to represent yourself, because this matter is going to be set for a trial?
I understand. I would like to continue with the trial option.
All right. How many days? 1 day?
1 day.
And Ms. Scottston, you have an option. You can either say, you know what, I want to have a full 12-member jury to decide this case, or you can have it be heard only by myself, which is called a bench trial or a court trial. Do you have an idea of whether you want to have a jury trial or a bench trial?
A bench would be fine.
Okay, all right. So 1 day bench trial. It's gonna be a while, unfortunately. The first available date I could do would be June 17th. Wait, with a bench trial, do you think we need a full day?
Let me look at my witness list.
If you are selecting a bench trial, that could shorten it up, so we may not need a full day, because half of the day consists of picking a jury.
I don't think we'd need a full day now.
All right, so Ms. Scottston, do you wish to have this resolved as quickly as you practically can? Or are you okay with having it be heard in June? Well, it looks like June, that's your first date and time anyway. I could do June 8th from 9 until noon. It is an ADA week, but that's the first available time I have. Or
I would be available.
Okay, or I could do June 15th from 9 to noon, and that is your week.
I would much rather that one.
All right. Are you available June 15th, Ms. Scottston?
Yes, I am.
So let's schedule this June 15th. It says only one DA though.
Yep, so it's me.
Oh, it's Jose's on vacation. All right, so from 9 until noon on June 15th, all right? You do still have a right to have an attorney. That right does continue, or you do have the right to present your own evidence and be your own counsel. So just think about those options and those things. Otherwise, I will see you. Oh, we need to set a final pretrial. Sorry. All right, a final pretrial, Ms. Scottston, is where both parties update the court and say, you know what, there's no way this is going to resolve, or this matter, and so this matter is continuing to trial, or we have reached a resolution and we could possibly handle it and take care of it that date and time. I can schedule you for (9:45) on May 7th, 9:45 on May 7th. And if it's going to resolve, and let's say that you think about it and you're like, I do wish to accept that deferred judgment of conviction offered. In a case like that, where you would need to have a signed document, you would need to be in person. Otherwise, for a final pre-trial, you can appear by video conferencing like you're doing here today. And if the matter resolves in some other way other than needing a signed document, I'm okay if you appear by video that way as well. Okay?
Okay, thank you.
I'm sorry, I missed what date and time you said?
May 7th.
What time?
9:45. All right, anything from either party?
Just, I think on that date, we'll need to do colloquy for the right
Yeah,
to
I know.
counsel.
I sure do know that.
Okay, that's all.
All right. All right, then if nothing from you, Ms. Scottston, then we are adjourned.
Okay, thank you.
All right, thank you. We will go on the record in the matter 25 CF 41, State of Wisconsin versus Heather Honeycutt. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Honeycutt appearing by video conferencing in custody in Burnett County Jail. We have her attorney, Tripp Stroud, by video as well. We're set today in this matter for a plea hearing. The parties have reached an agreement, and so we've scheduled this for a plea today. Ms. Honeycutt, you are appearing by video conferencing, as is your attorney. At the last hearing, you indicated and told the court that you are okay with that for this hearing. Are you still okay with that?
I think the lawyer had some things that he wanted to state.
Oh, all right. Sorry, Mr. Stroud.
Thank you, Judge. I didn't want to interrupt, so what Ms. Honeycutt and I were talking about is the restitution filing that was that we received this morning. So that's document number 86 in the court record, and the top line amount of restitution that's being claimed is $310,000.
Yes.
That's different than the restitution request that was originally submitted, which was for $147,348,000. So
yes.
just
I
a little
noticed
under
that
100.
Yeah, I noticed that significant difference as well, because I did review it this morning or whenever it was filed prior to this hearing. And I'm interrupting, trying not to interrupt, but I did recognize that and notice that as well. And that is something that if you wish to have a restitution hearing, that is something that is your right, Ms. Honeycutt's right to be able to do that. So I'm not sure if that impacts a plea today, but you let me know that.
Well, I'll say this, and I think the state should have an opportunity to respond. We did agree to that there would be a stipulation to the amount of the restitution. I was going off of the amount that was the $147,000 amount. So I think this is a significant difference, and I would request a restitution hearing as to the amount. But it was part of the agreement that we had that we wouldn't be disputing the amount.
And that is understood. And Mr. Schmidt, does that impact the ability to reach an agreement here today if they are then going to be requesting restitution hearing, since there is a substantial difference from the original dispositional supplement that was filed versus the one that was filed today?
What about a stipulation as to what the amount was previously in their restitution hearing as to the difference?
You can think about it. Do you want a breakout session?
Yes, Judge. Thank you.
All right. Ms. Honeycutt, I'm going to give you a breakout session with your attorney again, and then we will come back, okay?
This case may be over for today, but the real question is far from settled. Was this a fair second chance, or a warning about the consequences of every decision? Let us know your thoughts in the comments below. And if you enjoy real courtroom moments and shocking legal cases, don't forget to like this video, subscribe, and turn on notifications so you never miss the next case.